Order. Sir George Howarth to move the motion.
I beg to move that this House has considered Petition 206851 relating to a public inquiry into the James Bulger murder case. I'm pleased, Mr Henderson, to serve under your chairmanship, and can I thank the Petitions Committee for granting this opportunity to debate the petition, which refers to the concerns people, particularly James Bulger's family, have about what has taken place since James's brutal murder on the 12th of February 1993, and their belief that there have been failures in the system. The petition, which is signed by 213,624 people, over 8,000 of whom are from Knowsley, was in place in 2018, but has been subject to a lengthy delay because of a parole board hearing related to further offences committed by one of James's killers, known at the time as John Venables, which was judged to render any debate on the subject sub judice. Now that the parole board has rejected John Venables' application for parole, I'm grateful that this debate can now take place. I intend to begin by reiterating the sickening and tragic circumstances of James's murder. I apologise in advance that those listening will find it harrowing to hear this account of what happened, but it is, in my view, necessary to remind ourselves as to why this matter is so visceral, and consequently there are questions, the answers to which are long overdue. John Venables, then aged 10, together with another child of a similar age, abducted 2-year-old James, took him to a railway line and savagely murdered him. Denise Fergus, James's mother, described in her book, I Let Him Go, what occurred on the shopping trip to the Strand shopping centre in Bootle on the day that James was abducted. She said, and I quote, "The shopping centre was packed full. James couldn't believe his luck. For once, he was in among the crowd. I held onto his hand, but inevitably, he would run a yard or so ahead of me, always where I could see him." The shopping trip concluded with one last stop, a butcher's, which is where the abduction took place. In her own words, she describes in the book what then occurred, and I quote, "There's been so much written about what happened and so many opinions given, but I want to make one thing clear. I absolutely did not leave my baby outside the butcher's on his own. I would never have done so. He was with me and holding my hand as we went inside. The only time I let go of his hand was to pay for the chops I'd bought, and he was standing right beside me. I picked out the meat I wanted and took my bag from my shoulder, got my purse out and opened it to count the money. And when I looked down, James was gone." She goes on, and I quote, "There were rumours that circulated afterwards that I had been shoplifting with my mum. Firstly, I've never stolen anything in my life. And secondly, my mum wasn't even with me on that day. If extra proof were needed, my whole shopping trip was captured and examined frame by frame once the police went through edited CCTV footage. It clearly shows that before 3:39 I was shopping, and after 3:39 my world came crashing down as I frantically tried to find my boy." 2 days passed as James's family were understandably in extreme distress, and the police and family members searched for James, having found additional CCTV footage that showed he'd been taken away by 2 older boys. On the Sunday following James's abduction, Denise was called to attend the police station, and after an agonising 40-minute wait, one of the police officers investigating the case, Jeff MacDonald, told her, "We found him." and it's not good news. As the MP for the area, I was appalled as everyone else locally, but the wave of public horror was nothing compared to the trauma experienced by James's family. Losing a child at any time goes against the natural order and expectations of any parent. To do so, however, in such harrowing circumstances is indescribable. Subsequently, the two boys who had abducted and killed James, Robert Thompson and John Venables, were arrested, prosecuted and found guilty. During the ensuing years, many questions and frustrations about how matters have since been dealt with have been raised. I will refer to some of those questions later. In the meantime, I want to place on record a statement that Denise has helpfully provided me with, and I quote, "Honourable members, I ask you with a mother's heart to consider the questions and pleas I've laid before you, to try and understand that no mother can simply accept that errors were made or that crucial facts were brushed under the carpet in the case of my child's murder. For 31 years, I've fought tirelessly, not because it will bring my precious James back, but because he and every child like him deserves justice. This isn't about the past, it's about the future. It's about ensuring that no other family has to endure a similar ordeal, that no other child's life is undervalued by the justice system. We have the power to make changes, to right the wrongs, and to honour the memory of those we've lost by protecting the innocent. Please, I beseech you, to take these matters to heart. Consider the impact these errors and omissions have had, not just on my family, but on the integrity of our justice system." James's voice was silent too soon, but through your actions, his legacy can be one of change and hope. Now, as I mentioned earlier, I have some questions for the Minister, and I look forward to his response. First, why was the evidence gathered by Merseyside Police indicating that Thompsons and Venables sexually assaulted James prior to killing him not presented at the trial in Preston Crown Court or to the parole board when Venables was released in 2001 and again in 2013? Who made these decisions? Secondly, the conviction of Venables in 2010 for possession of extreme child pornography proves Venables' sexual interest in children. Was that sexual interest in children missed by all the experts, or was it known? Thirdly, was a proper consideration of the attempted abduction of another child earlier in the day that James was murdered, indicating premeditation, given at the trial and later at the parole hearings? Fourthly, were Thompson and Venables pronounced rehabilitated in order to avoid them entering adult custody without proper regard to the potential risk posed to children? And what representations did Lord Chief Justice Wolfe make to the parole board? Before I conclude, there are a couple of points I would like to cover. First, although not directly related to the petition, a few comments on some of the media coverage of events at the time of James's murder and since have been unacceptably intrusive in respect of family members. At the time, in breach of the then Press Complaints Commission guidance, the intrusion into private grief was callous and cruel. In principle, there is a remedy available by means of a formal complaint on those grounds. Many people affected are understandably, however, wary of doing so, as a published apology in print is usually small, hidden and accompanied by a repetition of the original intrusion. Breaches should incur heavy penalties on media outlets. Secondly, the question I've referred to earlier exposes the fact that the initial response, whether judicial or on the part of government departments, often becomes increasingly opaque and confusing as new information comes to light. A good example of this problem can be found in the government's response to this petition, which unfortunately is both overly defensive and vague as to how the transparency of the parole board decision-making can be increased and how its decisions can be challenged. In February 2010, John Venables was recalled into custody, following which Sir David Oman was commissioned to conduct a review into the handling of the John Venables case between 2001 and 2010. Sir David concluded that case management of John Venables' case more than met the national standards laid down for the supervision of serious offenders in MAPPA 3 level. He further concluded, with reference to the further serious offence, that, and I quote, "Evidence classed as low probability do unfortunately happen, despite everyone's best efforts. That's the difference between low risk and no risk." I should say that I know Sir David personally and have great respect for his public service over the years. His conclusions, however, inevitably reflect the narrow terms of reference that he was set. As the helpful House of Commons Library debate pack points out, for example, the terms of reference did not extend to Venables' time at the Red Bank Secure Unit. It did not, therefore, examine allegations reported in the press that Venables had an inappropriate relationship with a female member of staff at the unit. The petition calls for a public inquiry in order to address the issues that remain to be cleared up. On the basis of the government's response to the position, regrettably, it seems unlikely that a public inquiry will be granted. If I am correct in that assumption, I would therefore finally ask the Minister if he will consider what alternative might be appropriate. I do not expect that he will be in a position to do so today, but would urge him to give that matter serious consideration, because I do think it is important that these questions and these concerns are answered as fully and comprehensively as possible.
The question is that this House has considered E-petition 206851 relating to a public inquiry into the James Bulger murder case. And before I call members to speak, I would like to remind members that there is a court injunction about the release of information relating to James Bulger's murderers, including information about their current identity and whereabouts. And I ask members to be mindful of this. Jess Phillips.
Thank you, Mr. Henderson. So I'm going to, for the bulk of my time, dedicate my voice to the voice, as my honourable friend from Knowsley did in part as well, to the voice of Denise Fergus, James's mother. And like my honourable friend, I have a statement here from her. So, honourable members of the House of Commons, my name is Denise Fergus and I am present today as the mother whose heart has been shattered and whose life has been forever darkened by the loss of my dear son, James. For over 30 years, I have carried the unbearable weight of his absence, a void that can never be filled, a pain that never subsides. When James was so cruelly taken from us, the justice system promised retribution and rehabilitation for his killers. Yet the sentences they received meant they would never face the reality of an adult prison never undergo the rigorous rehabilitation that such a heinous crime demands. As time passed, I learned more about the circumstances of my son's case, details that, had they been considered, could have significantly altered the course of justice. It was in the depths of despair, unable to attend the trial, feeling as though I had been cast adrift in the endless night. The world around me was devoid of light, and even if I had been present in the courtroom, the words would have passed through me, leaving no mark, for I was consumed by grief. The repeated reoffending of one of James's killers, the last time being 6 years ago, reignited my fight for justice. I had always feared he posed a threat to society, and my worst fears were confirmed when he was convicted once more. It was then that I requested the full details of the post-mortem report, bracing myself for the truth I had long suspected, that my little boy had suffered injuries of a sexual nature. The confirmation left me numb, yet it also steeled my resolve to fight harder than ever to ensure that such a person would never walk free to endanger another child or another family again. There are so many unanswered questions that haunt me. Why were critical aspects of my son's case overlooked? Why did it seem as though the most damning evidence was swept aside? Why, in the hope that I would never seek truth? Why was the attempted abduction charge not given to the jury to consider? I am here to say that I will never stop fighting for James. He cannot stand up for himself, so it is my duty as his mother to be the voice, to be his champion. I implore members of the House to hear my plea. We must scrutinise the errors that were made, the sentencing that fell short, the conduct at Red Bank House, and the reports that were omitted from the Ormond Review, reports that Sir David Ormond knew of but did not disclose. I read these omissions with a heavy heart, knowing that they represent a failure in the pursuit of justice for my son. No parent should endure what I have. The loss of a child is an unspeakable tragedy, but to know that justice has not been fully served deepens the wound. I ask those there to stand with me to ensure that the mistakes of the past are not repeated, and to uphold the principle that every child's life is precious and deserving of justice. Thank you for listening to me and a mother's enduring love and unyielding quest for truth. So those are Denise's words, and I have got to know Denise personally over the last few weeks and months, and I seek to lend my voice to her campaign to get to the truth and access the justice that she has. And it's one thing for us to all read about John Venables being recalled to prison. It's one thing for us to read about it in the newspapers. It is a completely different thing to live every single day in fear, waiting for the next piece of news. And that is what is written on Denise's face when I sit opposite her. In answer to a question asked by my honourable friend from Knowsley on the public record around the breaches of both Thompson and Venables in between the dates of 2001 and 2018, again, provided in the very helpful pack collated by the library before this debate, it was found that 70 breaches of their life orders had been found in between the period, the 17 years between 2001 and 2018. What Denise tells me is not only are there issues around whether the terms of reference of the review, which has already been highlighted by my honourable friend, not to include the time where Venables is alleged to have had sexual relations with somebody meant to be in charge of him, but also the issues that Denise has asked us to consider about the previous issues of the abduction. But what Denise tells me is that when breaches have occurred, she isn't told about them in the manner in which has been promised to her by all sorts of standards set out for victims, is that actually when he was last recalled, it wasn't until a week later. And because it had been in the press that Denise was informed. The standard of communication which should be afforded to her and James's family in this case has not been delivered. And so with each and every time a victim of such a heinous crime, and I have dealt with many, many, many family members of people who have suffered murder, each and every time the state does not live by an obligation that it had previously promised that victim, it's just another bit of erosion to believe that the case had been handled well in the first place. So each and every time something goes wrong in this case over the last however many decades, each time it is a reminder that things were missed, that things weren't covered in the court case, that things didn't happen. And then we wonder why families call for public inquiry, because things got missed. Because we all know in the many cases we've handled, things get missed. And when things get missed, they get missed again in the future. And in the future, since James's death, things have been missed in this case. And this is a case where the glare of all of the media is on it. I handle cases where nobody knows the name of the little boy or girl who's been killed. I suspect that Denise Fergus is getting a better service than most. And the point of having public inquiry and truth and justice-seeking reviews isn't just for retribution, isn't just to satisfy and tick a box for a grieving family. It is to ensure that our systems are correct. My own child is sat in this room with us today. I want to know that when I'm not with him, that systems are in place to ensure that the I's are dotted and the T's are crossed. And for so many years, it has felt to James's mother that she was the last to know, that she hadn't been informed, that she had to find out years after the fact about sexual violence. It's no wonder then that we end up in a point where public inquiry is the thing that gets requested. It's no wonder, and it's the very least that they deserve.
Thank you, Mr Henderson. It is a pleasure to serve under your chairship, and thank you to my constituency neighbour, the Right Honourable Member for Knowsley, in bringing this debate today, along with thousands of constituents who have signed the petition to have this debate heard. The horrific abduction, torture and subsequent murder of James Bulger over 31 years ago shocked the nation, and particularly my home city of Liverpool, where it took place. It remains an act of unimaginable evil and something that continues to horrify my city and beyond. I would like to commend the bravery and persistence of James's mum, Denise Fergus, and her husband, Stuart, in keeping alive their son's legacy in the campaign for truth, justice and transparency. I'm not legally trained in respect of criminal law, but as a human, as a citizen and as a mother myself, you cannot help but assert that it is in the interest of the public and their safety, particularly that of young children, that John Venables should remain behind bars. I welcome the decision of the parole board late last year that refused Venables' release and that he could not be trusted outside of jail. No doubt the same issue will rear its ugly head in a couple of years' time. I hope common sense will once again prevail. Let us not forget, Venables is indeed a danger to the public, after being found of reoffending not once, but twice. I'm a firm believer in rehabilitation, but I also acknowledge that not everyone can be rehabilitated, and I think this is a case in point. Kim Morris, the chair of the James Bulger Memorial Trust, summarises the demands of the campaign effectively when she says, victims' families should have full access to all the transcripts, evidence, everything. If you went to trial, you would have access to all of this. So what difference does a parole hearing have? That's what we should be doing going forward. I know the Ministry of Justice are in some ways alive to this call. Since 2022, there have been trials to allow some access to the victims observing the hearing of the offender, with the view of rolling it out more widely in the future. I urge the Department to continue moving at pace in overseeing the delivery of the Parole Board Strategy 2023-2025. Specifically, it sets out its aim in relation to openness and transparency for the next 2 years and 5 years. In the next 2 years, the following steps are outlined. Victims able to observe parole hearings with greater ease across the country. Panels are trained and have the necessary guidance to ensure victim-observed hearings are effective. Support evidence-based research and analysis of both our current operating model and impact of reform. And then for the next 5 years, which is crucial to securing lasting change, it comprises of a more court-like operating model and redacted release decisions published in all cases by the Secretariat under delegated authority. That was not the case last year when the Parole Board denied a public hearing into Venable's parole decision. A hugely disappointing one, given many believe that the necessary adjustments could have been made to comply with the original High Court injunction on Venable's identity. Of course, I understand and respect the independence of the Parole Board, but I have no doubt there needs to be wholesale cultural and operational shift at the political level to deliver the changes required to give confidence and reassurance to the victims and their families. There have been clear historic failings in the system in respect to Venables, and retrospective transparency can be applied and must be applied. The Ormond Review in 2010 did little to instil confidence in the original decision in 2001 upon Venable's release. The mitigating circumstances leading up to his release and any potential influence of others at Redbank that allegedly engaged in gross misconduct must call into question the original decision. Why did experts consider John Venables to have been rehabilitated? I make no personal judgment on that decision, but I find it staggering to assert by denying a public inquiry that lessons cannot be learned. Mr Henderson, I support a public inquiry. Those in power trot out the usual lines. It's too expensive, time-consuming and resource-intensive. There's nothing to see here. Even after the likes of Hillsborough, the penny does not seem to have dropped. That victims might, just might, refrain from calling for such if the system and public sector agencies afforded victims transparency in the first place. If there is nothing to see here, let us have all the facts laid bare. The number of signatures on this petition demonstrates the clear strength of feeling on this matter, with over 3,000 signatories from my constituency of Liverpool Wavertree alone. Our city of Liverpool remembers James with fondness for the beautiful little boy he was, and with sadness that he did not get to live a life full and happy, fulfilling his ambitions and potential. That potential was suddenly taken away from him and his family in the most unimaginable and horrific of ways. To lose a child in such circumstances should never happen. For his family to still be fighting for justice 31 years later should never have to happen, and it is unbelievably cruel. I hope government ministers listen today, and once again I pay tribute to the bravery and persistence of Denise and Stuart Fergus and their wider family as they fight for justice in memory of James. Thank you.
Thank you, Mr Henderson. It's a pleasure to be here under your chairmanship. And can I thank my right honourable friend, the member for Knowsley, for bringing this to the floor, but to James's family for initiating this petition of 218,000 people, of which 5,000 signed in my constituency, the constituency of Bootle. The New Strand is a place in my constituency where James was abducted from and subsequently abused and murdered. And it still to this day resonates with the people of my constituency, as it does right across the country and particularly in Merseyside. So a tribute to his family for coming here and the bravery to do that. So thank you very much for that. I don't think I have a great deal more to add to my right honourable friend and my honourable friends. They are as ever eloquent, outlining clearly, unambiguously what should happen. They've set the context, they've set the scene, and I do really hope that the Minister will listen. I'm not going to take much time. I don't want to add to something that's already been said. I don't want to dilute it at all. What I can say is that the Public Inquiries Act of 2015 is in place. It gives the capacity for inquiries to be set up. It was set up because, in a sense, in the past, we didn't have enough inquiries in relation to these challenge to the justice that people should have. Whatever that inquiry is, we are here to ensure that people get justice. And in that regard, the Inquiries Act enables the consideration of us, of society, to respond to events of major public concern. Well, 218,000 people signing a petition is an indication of the public concern that people have in this. And that includes, as I said, 5,000 people in my constituency. Even the Public Administration and Constitutional Affairs Committee in 2017 basically expressed its concern about the ability of Parliament, colleagues here, to influence potentially when a public inquiry is called, and of course, to some extent, our oversight of that. And that's our job, and that's what we're here today to ask, demand, insist, whatever phrase we want to use, the government to set up a public inquiry. It's for the public inquiry to consider all the points that my colleagues, my right honourable friend and honourable friends have said today. It's for the inquiry to do that, so I'm not going to prejudge any of that. We've had a whole list of issues that that inquiry should look into, and I wholeheartedly agree with them. What my job here today, to back up my colleagues, is to say the Public Administration and Constitutional Affairs Committee has asked for it. The House of Lords has asked for this as well, for the more significant ability to intervene in relation calling for public inquiries, and the Institute of Government as well. Now, these bodies don't just throw these recommendations and suggestions around for the fun of it. They do it because of the experience we've had time after time in this country in relation to the lack of justice for victims. So I wholeheartedly support my honourable friend, my right honourable friend's call for this public inquiry. I absolutely and unequivocally support the right of the family to call for this inquiry, to demand this inquiry. I fully support that as well. And of course, I support my two honourable friends here today, who I have to say are absolutely fantastic in their pursuit of issues of this nature, and I'd like to thank them as well. Thank you.
Alex Cunningham.
Thank you very much, Mr Henderson. It's a pleasure to serve under your chairmanship this afternoon. And I thank my right honourable friend, the member for Knowsley, for leading the E-petition debate this afternoon, calling for a public inquiry into the conduct and the management of those responsible for the death of young James Bulger, as well as, of course, the case management itself. The abduction and murder of James shocked the nation to its very core, and many of us can still visualise the CCTV film of his abduction and the shattering events 31 years ago in 1993. I know I speak for the opposition and the whole House in saying the crimes of John Venables and Robert Thompson were absolutely horrifying. It's impossible as a dad and as a granddad to even come close to imagining the pain, suffering and trauma that Denise Fergus and Ralph Bulger have had to go through and will continue to go through for the rest of their lives. Our thoughts and our most sincere sympathies remain with them, both them and their wider family, and they have a considerable respect for their dignity shown in their grief. The way Venables' case in particular was handled continues to be of interest and concern to the public at large. This e-petition was signed, as we've heard, by 213,000 people, and, as referenced by the Right Honourable Member for Knowsley, was in place in 2018, but has been subject to delay because of a parole board hearing, which was judged to render any debate on it to be sub judice. I'm grateful to my right honourable friend for the way he spoke this morning, or this afternoon even, with sympathy and empathy, whilst demanding the answers to a series of precise and sensitive questions. And also to Denise, who was able to speak directly through him and through my honourable friend, the member for Birmingham Yardley. As we've heard, at the time of the murder, John Venables and Robert Thompson were 10 years old. They were sentenced to detention during Her Majesty's pleasure, a life sentence for children who commit murder. This case was subject to early scrutiny, first with the length of the tariff, and eventually the Lord Chief Justice ruled in October 2000 that the tariff should expire immediately, noting that any decision, however, as to when Thompson and Venables would actually be released would be for the parole board. Venables was held in a secure children's unit, Red Bank Community Home, until his release under licence in 2001, and as Denise said in her statement, didn't by then serve in an adult prison. He was then granted a new identity, and a lifetime High Court injunction was issued to restrict publication of information about this new identity. But Venables, as we've heard, was recalled to custody in February 2010 and convicted in July that year for the possession of indecent images of children. His crimes and convictions led to all manner of questions about how he had been managed and supervised. Both the probation service and the parole board operate on two basic principles: public safety and public trust. They exist to keep us safe, to protect us from dangerous criminals, and to ensure that the public, especially victims, have faith in the justice system. In response, the Justice Secretary commissioned Sir David Almond to review the Venables case from 2001 to 2010. The review's terms of reference did not extend to Venables' time at the Red Bank Secure Unit. It did not therefore examine allegations, and we've heard of this already, reported in the press that Venables had a relationship with a female member of staff at the unit. The Almond review concluded that the case was managed appropriately by the relevant authorities. He said, "I have established that despite the continuing low underlying risk assessment, significant resources were applied by the Probation Service and Home Office and then by the Ministry of Justice after the machinery of government changes in 2007 to this case, allowing case management to much more than meet the national standards laid down for the supervision of serious offenders at the MAPA 3 level. It further concluded that the professional assessments were made appropriate given the evidence available at the time, and I will again quote from the report. He did go on to commit a further serious offence, but that does not in itself mean that the assessments made throughout the case of the low risk he posed to the public were wrong-headed. I conclude that there was a correct professional assessment on the evidence then available. Events classed as low probability do unfortunately sometimes happen, despite everyone's best efforts. That is the difference between low risk and no risk. Venables was again released under licence in August 2013, but recalled to custody a second time in November 2017 for the same offence. He received a 40-month period of imprisonment and remains in prison, having been refused parole at private hearings held in September 2020 and December 2023. The e-petition mentions specific concerns around why Venables was judged to have been rehabilitated. While the probation and parole board documents are not in the public domain, it is clear that the public would question just how this decision was made, especially in 2013, when Venables was again released from prison, only to be recalled. The Government should, where possible, be transparent about the decision-making process, especially the adequacy of risk assessments carried out and how a judgment was reached about his rehabilitation, and equally how the judgment of rehabilitation was challenged and cross-examined. Whilst we have had the Ombudsman review in 2010, which looked in detail about how Venables was managed and overseen upon his first release, we have not had a similar review about his release in 2013 or his subsequent recall to prison. This is why a number of questions remain outstanding, including about how a judgment was made in 2013 that it was safe to release him. And my honourable friend highlighted the dozens of other breaches of his licence conditions. Was that not a sign then that this guy should not have been released? The probation service has a vital duty and role to play around public protection, especially for those being released from prison and having committed the most serious of offences, such as murder. While I am not commenting on the specific nature of Venables' recall in 2017, we have long been concerned on this side of the House about the gaps in our criminal justice system, which means that dangerous offenders are being released, they're not being properly monitored or assessed by the probation service, and then they're going on to commit further serious offences. This poses a huge risk to public safety and undermines faith and confidence in our justice system. Now, we know that our probation service has been through shake-up after shake-up over the last 14 years, including the privatisation in 2014, the cutting of senior and experienced staff, and record high workloads for the staff themselves. I hope the Minister, in his response, can outline what action the Government is taking to ensure our probation service and its staff are equipped, trained and supported to manage high-risk offenders better, and how we can work to ensure that the public, especially victims and their families, can have faith in them. As this House will know, the Parole Board rejected an application for John Venables to be released from prison just last year. The Parole Board operates independently from the Government and cited a number of factors when they rejected his application to be released. I note in reporting this decision, the Justice Secretary, the Right Honourable Member for Cheltenham, mentioned the Government's continued commitment to reforming the Parole Board. The Parole Board needs to ensure that it is protecting the public's safety and the public, especially victims and family members, have faith in its decisions. It's for this reason that we support and have long called for a mechanism whereby the Secretary of State can query a Parole Board decision with an independent court acting as a backstop. We believe this is a fair and practical reform that will build trust in the Parole Board, but equally will allow the continued separation between elected politicians and our judiciary. I will conclude by reiterating the complex and sensitive nature of what we've come here to discuss this afternoon. But I look forward to the Minister shining further light on this case, following the questions posed by my right honourable friend, the member for Knowsley, and for the family through my honourable friends. As said in the statement by Denise, which he put on record, this is about ensuring that no other family has to endure a similar ordeal. I look forward to the Minister's response.
Mr. Edward Bulger.
Thank you very much, Mr. Henderson. A pleasure to serve under your chairmanship this afternoon. And may I, at the outset, acknowledge, as other honourable and right honourable members have done, the dedication, the determination of Mrs. Denise Fergus, James's mother, in campaigning on this petition and in successfully securing a debate through the Petitions Committee on this hugely important matter. It is, as honourable and right honourable members will know, sadly the case that on occasions in this chamber, in the main chamber, we are called upon to debate deeply sombre, deeply traumatic and saddening matters. But it's right we do so, and that we cast that light upon them. And I'm also grateful, if I may say, for the tone adopted by all honourable and right honourable members who have spoken. And I think it's appropriate that this debate is conducted in that manner. And I pay tribute to Denise Fergus for her and her family's tireless and dignified campaign to obtain justice for her son James, so cruelly taken from her in February 1993 when he was just 2 years old. We've heard today from the Right Honourable Member, the member for Knowsley, the circumstances that to this day remain shocking and harrowing, and no one can fail to be shaken by them still, even after the passage of time. The murder of James was a crime which rightly shocked the nation and continues to do so. I recall, as the Shadow Minister highlighted, those harrowing images on CCTV when I was still at school many years ago. I recall the dreadful inhumanity of the evil that we all sadly realised at that time had taken place. Not just because of the horrendous events themselves, but also the shock that they were carried out by two 10-year-old boys. Now, I'm grateful as well for the recognition in the course of this debate that, of course, many of the decisions made in the context of this case were made by independent bodies, the CPS, the sentencing judge, the parole board, and I'll turn to that in a moment. Now, both Thompson and Venables were, as has been said, released in 2001 on the recommendation of the parole board, subject, as the Chair has quite rightly drawn attention to a lifelong anonymity order granted by Dame Elizabeth Butler-Sloss. Thompson has remained in the community on life licence without further offence. However, Venables has, as been set out today, twice been recalled to custody and subsequently convicted of further offences involving the possession and sharing of illegal images of children. First in 2010, when he was sentenced to 24 months imprisonment, and having been re-released on the direction of the parole board in 2013, again in 2018, when he was sentenced to 40 months imprisonment. And since he became eligible to be considered for release on life licence following recall, as again has been alluded to, the parole board has found on 3 successive occasions, most recently December last year, that it remains necessary on the grounds of public protection for him to remain confined to custody. Now, against that background, I think anyone could very well understand the concerns surrounding that first release decision in 2001, and specifically could understand and appreciate the current call for a public inquiry. However, while I do fully appreciate the significant concerns which have been expressed, and indeed the strength and sincerity of the feelings on this issue, I'm afraid I'm not in a position today to announce a public inquiry, though I appreciate that will be disappointing to those in the gallery, but also to honourable members opposite. But I would say, and I will return to this end, I am open, if it is helpful, if he considers it helpful, to meet with the right honourable gentleman to further discuss this matter, and indeed with his honourable friends, if that is helpful in this context, to have a further conversation about the matters we are debating today. As has been highlighted, the government had previously commissioned, the then government had previously commissioned the Ormond Review. This was published on the 23rd of November 2010, which, in looking in detail, found, as again honourable members have said, that they did not question the decision of the parole board that they made at the time in recommending Venables' release in 2001, again based on the evidence at that time. The review looked in considerable detail at the management of Venables and made detailed recommendations to address the shortcomings in supervision which have marked some of that period. The subsequent period of supervision from 2013 to 2017 was consistently tight, and in fact was thereby the means by which the further offending came to light and subsequently a successful prosecution was able to be mounted. Now, as I said, I do fully understand why the nature of that further offending gives rise to significant concerns as to whether the decisions to release him were defective. It may be helpful if I briefly provide a little more explanation about how the parole board determines whether prisoners serving life or other indeterminate sentences are released. For any offender sentenced to life imprisonment, a minimum period of that imprisonment is set for the purposes, of course, of punishment and deterrence. After the minimum term has been served, by law, the prisoner may continue to be detained in custody only for so long as their risk requires it, or, in other words, unless the prisoner's risk can be effectively mitigated and managed in the community by means of the obligations and restrictions of a post-release licence. Where it issues a release direction, the Parole Board is concluding that the probation service and partner agencies, taking account of the powers which arise from a post-release licence, have the means to mitigate remaining risks and so prevent the public being exposed to undue risk. Now, obviously, as has been alluded to, any such decision does involve a judgment, and the Parole Board can regrettably never be completely certain that any prisoner it releases may not re-offend. When the Parole Board determined in 2001 that Thompson and Venables were safe to be released, it took account of risk assessments and reports provided by various professionals. And by the time of the release, each completed their minimum term. Now, as I've already mentioned, when Venables was recalled to custody in 2010, the then Secretary of State for Justice, Jack Straw, asked Sir David Ormond, the former Permanent Secretary at the Home Office, to undertake a comprehensive review of the management of Venables and set the terms of reference for that review. The version of a response, I should say, of that review was published in November 2010. And I say a version because it was, as honourable members will be aware, redacted to comply with the terms of the order of the court in respect of anonymity. But that redacted version is available on gov.uk. Now, in his review, again, as has been alluded to, Sir David noted that Venables had been detained in Redbank Secure Unit run by St Helens Borough Council. During his time at Redbank, an allegation was made about an incident involving him. Now, I'm aware of the press reports speculating about the nature of that incident, but I have seen no contemporaneous official account of that. Therefore, and I appreciate this will be a frustration potentially for those listening, I do believe it would be inappropriate for me to comment on the basis of the press reports alone. Yeah, of course, I'll give way.
I don't think anybody here would expect, we are not judge and jury in this building. But as you said, that Jack Straw was the last person to put a review into this. And if the Minister cannot, as he has outlined, a full public inquiry, is there not absolutely a case to have another review that had a look into Redbank, but also in the period of further mistakes happening since 2010, because all we have currently is one from 2001 to 2010. Surely there is errors been made that need some transparency post that.
Well, I'm grateful to the honourable lady, and at risk of potentially damaging her reputation, she knows I have huge respect for her, and have done a lot of work with her when I was the Victims Minister previously and when she held the role of Shadow Safeguarding Minister. I appreciate the point she makes. Without prejudice to any decision made, I have made the offer to meet with the right honourable gentleman. I'm happy to have a conversation. I don't want to, and I hope she knows from her previous interactions with me, I don't want to raise expectations that I can't meet, and don't intend to do that, but I will have a conversation with the right honourable member. However, the Home Office, in respect of Redbank, the Home Office asked an experienced former prison governor, Arthur de Frisching, to look into the incident there. And it appears, and this is some years after the event, that no formal reason was found to publish a report into the incident at the time. St Helens Borough Council observed in a public comment that all allegations have been thoroughly investigated, but no copy could be found in the archives of either the Home Office or the Ministry of Justice of that. While the terms of reference for his review began with the preparations for the release of Venables, Sir David stated he'd found nothing in the material which he had considered to cast doubt on the fundamental judgments made by the Parole Board at the time the statutory release test was deemed satisfied. Venables was recalled when police officers, having arrived to escort him to a new address on account of concerns for his safety, caught him trying to remove the hard drive from his computer. This led to an investigation which resulted in his first conviction for downloading and sharing illegal images of children. Now, in Sir David's report, he made a number of recommendations designed to strengthen the future management of Venables and indeed of Thompson. Those recommendations recognised that the primary responsibility for supervising Venables lay with the probation service, working closely with the police and other relevant agencies under the statutory MAPA arrangements. In Venables' case, this meant that the key actions to manage his risks are discussed and agreed at formal meetings attended by senior representatives of the probation service, police services, as well as highly qualified other specialists, for example, psychiatrists. When he was re-released in 2013 on the direction of the Parole Board, the Board set the robust licence conditions it considered necessary to enable the probation service and its MAPA partners to manage him effectively, to mitigate his risk and to help protect the public. There was now a clear difference between the way he had been managed in the period 01 to 10, as covered by the Ormond Review, and the way in which he would be managed from 2013 onwards. It is, of course, deeply regrettable that in 2017 Venables was discovered to have been once again downloading and sharing illegal images of children. However, unlike in 2010, his offences were quickly discovered as a direct result of the monitoring and supervision that had been put in place. And there were immediate consequences with his return to custody. Now, as I've set out, 3 times now the Parole Board has concluded that Venables remains too high risk to be released on life licence. For his most recent review, my right honourable friend, the Secretary of State for Justice and Lord Chancellor, submitted an overarching Secretary of State view recommending Venables remain in prison on account of substantial concerns over his risk of reoffending and the risk of harm to the public. There are a number of points that, Honourable, before I respond to the Right Honourable Gentleman's specific questions, and I will endeavour to do so with as much information as I can because I believe that's important. The honourable members opposite have highlighted, and I think the Honourable Lady Member for Liverpool Wavertree, the Honourable Lady Member for Birmingham Yardley, and indeed the Honourable Member for Bootle in different ways, have highlighted the impact that such matters can have on victims' trust in the system. And as a former victims minister working with the Honourable Lady and others, I saw that firsthand. And that transparency, that trust, that engagement is central to building the confidence of those who are victims of crimes or have been victims of crimes in the system. So there are a number of points raised by honourable members around that. In respect of, and I think it was the Honourable Lady Member for Birmingham Yardley who talked about notifications or lack thereof of breaches. Now, my understanding is that the supervising agencies concluded that the threshold for recall to custody based on those breaches or a number of those breaches was not met, therefore a recall did not take place. And the notification comes where a recall takes place. So because the probation officers and others did not deem that the threshold for recall had been met, there wouldn't have been a notification. But I'm happy to take that away and reflect on that further. She and I sat in a bill committee where we were looking at the Victims Code, notifications, victims liaison officers, so I'm very happy to have another reflection on that. Can I just answer 2 more points raised, and of course I'll give way to the Shadow Minister after that. In terms of transparency, since those original Parole Board hearings, since the original case, we have made progress, and I'm grateful to honourable members for highlighting the progress that has been made. And I think it was the Honourable Lady Member for Liverpool Wavertree who highlighted the steps forward that had been made. Victims may now apply for a summary of a board decision. They can also apply for the hearing to be held in public. Now, the discretion still rests with the chair of the Parole Board, who takes into account a range of factors, but there is now that opportunity for a public hearing to be requested and potentially granted in the interests of transparency. In terms of the Shadow Minister's point about what powers there are to challenge decisions and such like, in July 2019, the Parole Board rules were changed to allow the Secretary of State to apply for the reconsideration of a release decision. And victims of crime and families of victims of crime may, of course, also now make representations to the Secretary of State as to why the Secretary of State should put forward a Secretary of State overarching view calling for the Parole Board to reconsider or not release. I give way to the Shadow Minister if he wants to still intervene.
Thanks for giving way and for answering the point that I specifically raised. I wanted to go back to the 70 referrals, and I accept that it was referrals rather than confirmed breaches. But even if, 10, 15 of those particular breaches, referrals were considered to be breaches of his licence, they may well have been minor, but don't they have a roll-up effect that, you know, he's constantly breaching, or being referred for breaches, and therefore maybe more serious consideration should have been taken to that?
Well, I'm grateful to the honourable gentleman. The context in which I addressed that was the point made by the honourable lady about notifications and threshold. Those previous breaches, cumulatively, where there's a breach, where there's another breach, it may not bring about a recall, but a probation officer managing that case will look at all those cumulatively and judging whether, when a further breach occurs or anything along those lines, whether that cumulatively there is a pattern of behaviour that changes. So I'm wary of questioning or speculating, I should say, on the individual decision-making of an individual probation officer, because I won't know what factors they will have taken into account in an individual case, but they do consider those matters. But there were 5 very specific questions raised by the right honourable gentleman, and I will try, insofar as I can, to give him some answers or more information than perhaps is already out there. Firstly, he asked about the evidence presented at the trial. Now, the police and Crown Prosecution Service, who are independent of government, will have put all relevant evidence to Press and Crown Court that they believe was material to secure a conviction when Venables and Thompson were tried for James's murder. The specific question of whether particular pieces of evidence should have been presented to the court and what was, or indeed were not, is, I'm afraid, a matter for the police and ultimately for the prosecution lawyers in building that case, how they determined what evidence to present to secure the conviction they wanted to secure, and would be a matter for the CPS. If I can just finish the point, and of course I'll give way to the Honourable Lady, but I am, with the caveat that I recognise and put on record the independence in its decision-making and how it conducts a case of the CPS, I am happy, of course, to highlight the points that have been made here today to the Attorney-General and the Solicitor-General, who, as honourable members will be aware, have oversight of the CPS. I'll give way to the Honourable Lady, then the Right Honourable Gentleman, of course.
I think, and I apologise if this is what my Right Honourable friend is going to say, it's not even so much the issue that we all know that the CPS have to build the best case for getting a conviction, and some things will get left out and some things won't. But what is concerning is that the sexual element, if when left out in a court case, how can the public be certain that then that is taken account of in a parole hearing? So if the sexual crimes had definitely featured in the court case, the sexual crime element would be part of the consideration in the parole, and that's the disconnect, I think, that we're concerned about.
Well, I'm grateful to the Honourable Lady. As I say, the decisions on what to include or not are ultimately down to the prosecuting counsel, prosecuting lawyers from the CPS. But I will, in a moment, when addressing a further question posed by the Right Honourable Gentleman, touch on those aspects. But I'll give way to him, of course.
I'm grateful to the Minister for giving way. The point that I think my honourable friend, the member for Birmingham Yardley, was making is that had that information been available at the time and during the trial, then subsequent decisions that had to be made would have taken on a whole new life. She accepts, and I accept, I think we all accept, that the judiciary is independent and prosecutors should be able to decide what evidence they use. But in this particular case, that omission could have led, probably did lead, to decisions being made in later years that would have been different.
Well, I'm grateful to the Right Honourable Gentleman. Actually, I've come on to address, to a degree, that specific point, actually, in saying that notwithstanding how the CPS, how the case itself was conducted and what evidence was used, when recommending their release in 2001, I advised that the Parole Board would have been given all relevant information, but I will undertake further inquiries to see if, this far down the line, it's possible to ascertain what, and within what I can reveal publicly, what that might have constituted. In 2013, the Parole Board did, of course, have full details of Venables' conviction for downloading and possessing illegal images of children, and therefore was able to take that into consideration when considering the risk of sexual harm which he presented to children. The second question And Right Honourable Gentleman is always welcome to correct me if I miss his questions or I miss one out, but hopefully I won't. He asked if Venables' sexual interest in children was missed by all the experts or if it was known. Again, having discussed this with my officials, my understanding is that prior to his recall in connection with possessing illegal images of children in 2010, the supervising agencies were not aware of Venables' sexual interest in children. However, they were aware of his broader risk to children, obviously arising in large part from the horrendous events of the murder of James, and that risk was then central to their ongoing management of him. The third question posed by the Right Honourable Gentleman was if proper consideration of the attempted abduction of another child earlier in that day that James was tragically murdered was given at the trial and at later parole hearings, if I recall. To try to respond to that, premeditation is, of course, relevant when it comes to any conviction for murder as a necessity for securing the conviction. As honourable members again would expect, it falls to the CPS and the sentencing judge to consider this factor. The parole reviews in 2001 and 2013, I understand, proceeded on the basis that Venables had been lawfully convicted of murder and of the premeditation and planning that was involved in that. And the parole board release decision in 2013 records the board's awareness and consideration of attempted abductions earlier in the day. As to the question about whether Thompson and Venables were pronounced rehabilitated in order to avoid them entering adult custody, honourable and right honourable members, I should perhaps clarify for honourable and right honourable members that it's not the role of the parole board to pronounce an offender rehabilitated, but instead is constrained to applying the statutory release test when considering whether someone should be released. That is, whether it is necessary on the grounds of public protection for the offender to remain confined in custody based on available evidence. I appreciate that that may appear like a sort of legal splitting of hairs, but there is a slight and subtle difference there in that statutory release test about whether there is a necessity on public protection grounds for someone to remain in custody or whether they are deemed to be rehabilitated and a reformed citizen. There is a legal differentiation there. And therefore, in recommending their release in 2001, the board determined that the risks which Thompson and Venables presented were capable of being managed effectively in the community on the basis of their judgment through the restrictions and prohibitions available through the life licence. Finally, the Right Honourable Gentleman asked whether representations were made by Lord Chief Justice Wolfe to the parole board. Now, again, I've asked my officials to look into this and to advise, and I can advise the Right Honourable Gentleman and honourable members that I am not aware that any representations were made by the Lord Chief Justice to the parole board. At the time, Thompson and Venables were sentenced to life imprisonment. It fell to the Home Secretary of the day to set their tariff, how long they'd serve, taking account of a recommendation made by the Lord Chief Justice. Therefore, any recommendations from the Lord Chief Justice regarding the tariff would have been made to the Home Secretary, but in respect of the parole question, I am not aware, having asked again and looked into the questions posed, that any such representations were made. I caveat it with that's the extent of my knowledge. I'd like to end my contribution to today's debate by again paying tribute to Mrs Fergus, not only for her tireless campaigning for James, but for her determination, as reflected in the statements read out by various honourable and right honourable members, to make a difference in the future, to help people learn the lessons, but also her determination to support young people by setting up the James Bulger Memorial Trust, which provides holidays and respite for families of disadvantaged young people who've been the victims of crime, hatred or bullying, and those who have made a positive contribution to the welfare of others or society in general. Now, the charity's motto is for James, as Denise rightly wants him to be remembered positively as, and I quote, the beautiful little boy with the bright, sparkling smile, and not for how his short life ended. I conclude by highlighting this has certainly been a sombre debate today, by paying tribute once again to the dignity and the courage of Denise and her family, to the Right Honourable Gentleman for bringing this debate and for approaching it in his typically measured, courteous and appropriate tone, and indeed to all Honourable and Right Honourable members who have spoken. This debate is a testimony to Denise's resilience, her determination, and above all, for her abiding love for James, and I hope that I will be able to continue the conversations around this with the Right Honourable Gentleman and others. Thank you very much, Mr Henderson.
To wind up.
Thank you, Mr Henderson. I will be brief because a lot of ground has been covered in the course of this debate. I'd like to thank, to begin with, Denise Burgess for first of all, for initiating the petition and also for the briefing that she's given and the inspiration that she's given for many of us. Well done. Secondly, I'd like to thank my honourable friends, the member for Birmingham Yardley, Liverpool, Wavertree and Boothall, for contributing to the debate in their own distinctive but important ways, and they've helped make it a much better debate than if it had just been me and the Minister and my honourable friend on the front bench. Turning to my honourable friend on the front bench, I thank him for the way in which he's listened to what people had to say and responded, and also the sensitivity he showed in the way he conducted his speech. And finally, to the Minister, I'm grateful for the constructive way in which he's responded to the debate, and I'm happy to take him up on his offer of a meeting to discuss the matter further. I'm sure family members would want to be present there. I do hope, though, that that constructive spirit continues, and the fear that I have, and it's not a criticism of the Minister, is that there have been so many false dawns in the past that, you know, could become another false dawn. I hope what we can agree on is a process which will resolve all of those issues, won't bring James back, but at least, as his mother said in her statement, it could help prevent anything similar happening to another child in the future. So I look forward to the meeting. I hope the Minister will reflect further on the suggestion I made as regards if they're going to rule out, by the way, I think there should be a public inquiry, but if that gets ruled out, there needs to be some alternative way by which these issues can be considered. And I hope he will give, I'm sure he will give thoughtful consideration to that, so that we can then have a meaningful discussion about how we proceed. Thank you.
Yeah.
The question is that this House has considered E-petition 206851 relating to a public inquiry into the James Bulger murder case. As many as of all that opinion say aye. Of the contrary, no. I think the ayes have it. Order, order. The sitting stands adjourned.
The proceeding has ended. The proceeding has ended. The proceeding has ended.